Senator Patterson.
Thank you. Chair, I have some questions about Ministerial Direction 110, if the relevant officials are available. But I will start with you, Minister. Obviously, the government made changes to Direction 110 after the issues with Direction 99. Would you say that Direction 110 is working as the government intended?
Oh, look, especially being the representing minister, I don't know enough about every case that's been decided under Direction 110 to give that sort of an opinion. Okay.
Secretary, do you think Direction 110 is working consistent with the government's stated policy intent?
So, Senator, the direction has been, obviously there are two stages in this, both the departmental decision and then any decision that might be taken at the AAT. And I'll let Mr Thomas take you through the statistics around how that's operating as a way of addressing that question.
Okay.
Senator, since the implementation of MD 110 on the 21st of June 2024 to the 31st of January 2025, MD 110 has had a loss rate of approximately 31%, which is comparable to the loss rate on previous MDs, going back to MD 79 in 2019. So it has reduced the overall loss rate from MDs prior.
The government, when they announced Direction 110, made it clear that their expectations were that community safety be put first, and that the purpose of it was to protect Australians. So, do you think it's achieving its policy intent?
Senator, in terms of guiding both the ART and the department, yes, it is guiding decision makers on decisions.
Yep, and is it ensuring that the right sort of people are allowed to stay and the wrong sort of people are deported as they should be?
I'm not sure that officials can be asked for opinions, which is
I'm just asking if the Direction 110 is achieving what the government set out for it to achieve.
Well, that you're asking for an opinion.
That's not an opinion. Is the policy achieving its stated intent? I'm not asking what
so,
opinion that...
Senator, I
should be.
Mr Thomas has indicated that the failure rates are consistent with MDs covering the same issue over previous years.
Okay. Are we familiar with the case of Michael Maine?
Yes, Senator.
And you're aware that the ART Deputy President last week ruled that Mr Maine should be able to remain in Australia?
This, just for context, this was the gentleman whose visa was cancelled by Mr Dutton in 2020, and that cancellation was quashed by the federal court, who found that elements of Mr Dutton's statement of reasons were illogical, with no logical connection between the evidence and the inference drawn. Is that the same, Mr Maine?
As we've discussed once or twice before, Minister, it's not my role to answer your questions in this forum. My question was to the officials as to whether they're familiar with this case, and sounds like they are. In the decision of the Deputy President of the now ART, one of the things that was cited was his significant relationships to Australia, was it not?
That's correct, Senator.
And isn't it the case that in Ministerial Direction 110, ties to Australia remains a primary consideration?
That's correct, Senator.
And wasn't it the case that the last coalition government Ministerial Direction, the name I can't remember now, the number I can't remember now, ties to the community was only a secondary consideration?
Senator, I think you're referring to Ministerial Direction 99?
No, the one that preceded 99.
Oh, 90.
90 or 79.
90, yes, I think it would have been 90. Is that correct?
Yes, Senator.
I think, Ms Sharp, you and I had a conversation about this in a previous hearing. Indeed. Where I asked, wasn't it a risk to keep ties to community as a primary consideration? Do you recall those exchanges?
Yes, I do, Senator.
And haven't those fears been borne out in this case?
I think, as we did talk about in that hearing, any MD can only guide a decision maker.
Indeed.
The decision maker cannot fetter or in any way direct a particular outcome. I think, as Mr Thomas has indicated, the overall rate at which the ART is affirming the department's cancellation decisions indicates MD 110 is working as intended. I think a loss rate of around 30% is something that as a department we're comfortable represents what you'd expect from de novo merits review.
Okay, so it's working as intended to allow someone who has killed 2 people to remain in our country.
No,
they're not
that is a
sentenced.
ridiculous misrepresentation of what the department is saying. And can I add, my understanding is the department is considering whether it will appeal the decision by the ART in this case.
I would hope so.
And that consideration includes analysing whether the ART incorrectly interpreted Direction 110. In addition to that, Minister Burke has requested that submission be provided to him so he can consider whether it is appropriate to re-cancel Mr Maine's visa if appropriate. And I remind you that Mr Maine would never have had to have been considered under Direction 110 if Mr Dutton had done his job properly in the first place and the federal court hadn't overturned Mr Dutton's original visa cancellation because his statement of reasons was illogical.
Thanks, Minister. So let's go to...
we're cleaning up Mr Dutton's mess.
Thanks, Minister. Let's go to another case. Officials at the table are familiar with BQHJ.
Do you have any surrounding facts that might jog out?
Yes, I can help you with that. And in fact, I can provide you with the ART's decision. I'll give that to the Secretariat. In BQHJ versus Minister for Immigration and Multicultural Affairs, a convicted rapist released as part of the NZYQ cohort applied for a protection visa and was denied. This man was convicted of an extremely serious rape in company, which he committed as a minor, and which involved the applicant and 2 other men driving an intoxicated young woman to an isolated place and sexually assaulting her. This individual also had domestic violence protection orders made against him. He appealed the decision to deny him a protection visa, and the ART sided with him and applied Direction 110 in doing so. They overturned the decision and they granted him a protection visa. Does that assist you to be familiar with the case?
I'm not familiar with that one, but we can certainly... if you have a question about it?
I will have a series of questions, but it'll be harder to ask if no one's familiar with it. Is there anyone in the room who's familiar with BQHJ?
No, Senator, not with the detail.
So he was on a BVR and that had monitoring conditions attached to his visa. But now that he has been granted a protection visa by the ART, citing Direction 110, he no longer has those monitoring conditions attached to him. Does that seem like a perverse outcome?
Senator, we're really not in a position to comment on individual cases in this way. What we did in the last instance was acknowledge the facts that were in the public and then speak about the application of MD 1110 generally. But in terms of commenting on facts of a specific case, that's not something we can do.
And just to reinforce what the Secretary said, if one of us were to comment on our opinion, and then if the Minister were to, for example, exercise his power under Section 501BA, any comment that someone from the department made, or even this kind of an exchange, could expose us to an attack.
Are proceedings of the Parliament protected by privilege? They can't be introduced into proceedings?
It still could. You'd be amazed what gets brought into hearings in terms.
Well, I mean, that would be a profound constitutional crisis if parliamentary privilege was being overruled by the courts.
I've looked very deeply at the issue of parliamentary privilege, I can tell you, Ms Sharp, and I believe it's extended too far by the courts, so I'd be absolutely amazed. But
Senator, I think the basic principle remains, though, whether or not what we say at this table can be used in a court proceeding. We don't comment on individual cases.
Okay, without commenting on the
case,
fair enough. Okay, without commenting on the case, at paragraph 64 of the decision, the tribunal member states, quote, "The strong ties that the applicant has to the Australian community is a factor that weighs heavily in favour of not refusing the protection visa. Isn't this the inevitable consequence of a ministerial direction that keeps ties to the community as a primary consideration?"
So I think Senator Ms Sharp has already provided evidence, and as has Mr Thomas, that the rate of failure, or in fact, if I put it the other way, the rate of our decisions being affirmed is similar to the directions which preceded MD 99 that were in place with the construct that you have outlined.
Okay. I presume then that you haven't had an opportunity to brief the Minister on this case if you're not familiar with this case?
Senator, in a general sense, all matters after a loss in the AAT are raised with the Minister's office within a couple of days for their awareness. They're then assessed against the thresholds in place. And then if they meet that threshold, a submission is prepared for the Minister in general. That's applied to all losses under MD 110. In addition to that, the Minister is able to request specific cases should he wish to.
Well, this decision was on the 5th of February. So if he was briefed within a matter of days about this case, he should have already been briefed, and surely someone here would be familiar with it.
So, Senator, I think we're going to have to take that on notice. There's a two-part process with ART cases. The first advice is simply a flag that it's been overturned, and our first process is to look at whether there is, in our view, judicial error in the decision.
Okay.
And then we turn to the question of whether or not the Minister wishes to intervene.
Sure. Well, could you take on advice whether the Minister is considering cancelling the visa, if he has the power to do so in this instance, and also whether the Department's considering appealing? And I'll just go to one other case, which is Fotu v Minister for Immigration. Is anyone at the table familiar with that case?
Again, if you could give us a brief summary, Senator, that would help.
Okay. So the matter of Fotu and the Minister for Immigration and Multicultural Affairs is a case from Western Australia in which the applicant, Mr Fotu, was convicted of making a shocking aggravated home burglary and armed robbery. The victim was a woman who was in her home having a shower when Mr Fotu and a group of young men smashed the rear glass sliding door of her home and entered the house. She was chased into the bedroom by Mr Fotu and 3 other men. Mr Fotu was holding a hammer. One of the men was holding an axe. These 4 men stood over her and demanded she hand over money and jewellery. When she pleaded to keep some of the rings that had sentimental value, one of the men raised an axe above his head and said, "Give them to me or I'll hurt you." The victim was understandably terrified that she was about to be raped or murdered. Mr Fotu was permitted to stay in Australia under Direction 110. And again, I can provide the ART decision for you.
Senator, I think our answer is the same, that we can't discuss this specific case. We can reaffirm what is happening more generally with Direction 1110, and we will take any more specific action on notice.
Okay, so this was...
I want to share the call in a moment. So
okay, last question on this matter.
Yeah.
This is a case from the 18th of December. Again, taking Mr Thomas's evidence earlier, if the Minister is briefed within days of any loss in the ART, he should have been briefed about this already. Has the Minister been briefed? Has he decided to cancel the visa? Is the Department appealing? What is the status of this case?
Senator, this case does sound familiar, but I would need to take it on notice to tell you exactly where it's at in the process.
So just conclude again, Minister, there's 3 cases now that we've discussed. Is that consistent with your hopes for Direction 110? Is that what the government hoped it would achieve?
I don't think that any government can ban the AAT making certain decisions. What a government and a minister can do is provide direction to the AAT about the government's policy on these matters. And it might be the right time to remind you, Senator Patterson, that when Mr Dutton was the Home Affairs Minister, he released 102 convicted sex offenders into the community from immigration detention, including 64 child sex offenders, and not one of those people was subject to any form of electronic monitoring, curfew or other conditions while they were released. And one of the people who he released from detention is one of the people who went on to be one of the alleged assailants of Ms Nanette Simons in her home in Perth in April this year. So, you know, governments, ministers do what they can with the AAT, but the AAT has the right to make these decisions. And you've already heard that as a result of Ministerial Direction 110, there has been a different approach from the AAT.
And Senator, I'd just make one more point that, of course, these cases are only in the ART because the Department has refused visas based on our interpretation of MD 1110.
Yes, and they've only been allowed to stay because of the ART's interpretation of Direction 1110.
Well, of the three cases you've presented to us, one of them involved someone who managed to get their visa cancellation overturned because Mr Dutton's original decision was illogical, with no logical connection between the evidence and the inference drawn. Let's have a look at the other two cases as well before we cast too much judgment.
Senator Patterson, I need to share.
Thanks, Chair.
Senator